Good evening, everyone. I'd like to welcome you to How to Write a Tax Efficient Will. It is my weekly session where I help everyone understand how to write a tax efficient will. And we discuss matters surrounding wills and lasting powers of attorney. I'm also happy for you to put things in the chat so that you can indicate some of the things you would like to have discussed. Tonight, we shall be discussing how you can save big on lasting powers of attorney. And I do hope that you will find this session very useful and of great assistance to all of you. I'd like to thank you all for being here. As I said last week, this session is mainly for persons who live in the UK. But if there are any other people from outside the UK, you are welcome. And I hope you can enjoy this session with us. I shall now move on to explaining who I am. My name is Deborah Bowers. I'm a STEP certified advanced will writer. I'm also a solicitor of England and Wales and a data privacy consultant. I'm qualified as a CIPPE and CIPM, and I am the author of How to Write a Tax Efficient Will. I must give you a disclaimer here because anything I say here is not considered to be financial advice, tax advice, or investment advice. You should not even take it as legal advice. We are simply discussing things which may be of importance to you. And the writing of wills is not a regulated activity by the Law Society. So what then is a lasting power of attorney? I think we should start by understanding what it is that a lasting power of attorney is and what it does. So a lasting power of attorney in this country comes in two forms. It comes in the form of a power which enables you to make financial decisions for someone else or health decisions for someone else. So if you are unable to manage your affairs, then you can appoint someone or you choose someone who can assist you with doing so. And it's in two forms, as I said. It relates to your property and financial affairs, and it allows you to choose someone to handle things like your bank accounts, your investments, your bills, or your property. It also comes in another form. It's in two parts: health and welfare decisions, which covers things like your health and your care decisions. So we shall now have a look at what the lasting power of attorney, which deals with financial decisions, looks like, and what your responsibilities might be if you are considering if you're considering to put one in place for yourself, or if you are deciding to allow someone to look after your affairs. So it enables people to run to the bank on your behalf. So they run your bank account and your savings account, making or selling investments. Sometimes you need to sell some shares, you need to sell some stocks. So they'll be able to do that for you. They'll also be able to pay your bills, or they will be able to buy or sell your home, because sometimes you need to sell your home. It depends on your circumstances, and you will need to sell your home in order for them to look after your care. Further, let us also have a look at what the one for health and personal decisions looks like. It is the sort of power of attorney for your health and care decisions, and the type for treatment and medical care, which you receive, including life-sustaining treatment. It can also help you decide, or help someone decide, where are you going to live? And it will address day-to-day matters such as your diet and your daily routines. So in relation to this power of attorney, which is your health and care decisions, we see, I would like to play a little game with you here, and we've got two different people here. We've got one set who look a bit like they're aging, and another gentleman who looks the picture of youth, really. And I would like you to put in the chat which of these you believe would require a lasting power of attorney. Which of these two? Is it A here, the elderly couple here, or the young man here? You can put it in the chat. Which of these do you believe would require a lasting power of attorney? Let's see what your answers are. Everyone's saying it's couple A. Couple A would be the ones who need a lasting power of attorney. Well, let's see if that's correct. Now have a look at this picture. Could you tell me which of these two people we just saw in A would be exempt, A and B? Which of these would be exempt from ending up in a hospital, unable to make decisions for themselves or unable to do anything for themselves? Which of these is exempt? Put it in the chat. Let's see what you come up with. Are either of these couples, either of these persons exempt from ending up sick in hospital and unable to make a decision for themselves, unresponsive, or just being supported or sustained by the health professionals? What if, for example, Mr. B, the picture of health, gets into an accident? Would he need someone to make his decisions for him, to assist him? None are exempt. That's right. Neither of them are exempt. So we shouldn't fool ourselves to think that because a person is elderly, they automatically need a lasting power of attorney, because neither the younger person nor the elder person is exempt. So the answer is both of them need to have in place a lasting power of attorney. I'd like to welcome whoever is joining us now. You've missed all the fun, but hopefully you'll still be able to follow. We were just indicating that there are here a young gentleman who looks the picture of health, and there's also an elderly couple who are looking like they can do with having a lasting power of attorney in place, but neither is exempt from ending up in hospital needing someone to look after their affairs on their behalf. So the answer was both. So neither of them are exempt. So both of them require a lasting power of attorney to be in place, because you never know when your circumstances can change and what can happen to you at any time. So at what point should you get your lasting power of attorney done or get it in place? Should you get it in place when the person that is in the picture here, you can see she needs a doctor to decide whether or not she's okay. We're not actually sure if she even recognizes the lady who is next to her or if she knows what's going on. And a doctor is certainly taking a good look at her situation to try to determine what it is or how best to assist her. Alternatively, we have this other lady here who, she was ill, but she looks a little younger, and the doctor is speaking with her, but there is much life left in her. So, you know, she needs, the doctor is speaking with her to maybe advise her to put things in order or to consider what her health status is. So we see here that at either stage, whether you are young or old or older, we need lasting powers of attorney. Now, what are the responsibilities, if any, of the persons who take hold of a lasting power of attorney on your behalf? So The attorney who takes hold of a lasting power of attorney on your behalf has quite a few obligations. And it's important that all attorneys know exactly what those obligations are. So, for example, the attorney must know that the LPA is a legal document. It is a legal document, that the LPA governs the mental capacity of, is governed by the Mental Capacity Act. And this Mental Capacity Act is a very important piece of legislation. Your attorney must follow those principles, the principles of the Mental Capacity Act, and your attorney must assume that you can make decisions for yourself unless it is established that you can't make those decisions. And we can determine, who then can determine that you can't make those decisions? It must be a doctor or person who is certified to do mental capacity assessments. So in some cases, you may need a psychiatrist if the person is also suffering from delusions of the mind. But there are ways that you can be guided, and a code of practice is available, for example, on the government website. So you can actually go onto the government website and get a copy of this code of practice so that you can consider whether or not the person you might have to look, you might need to assist, actually has capacities, not for you to make the decision, but you can at least use it to try to make a decision as to whether it's okay. We shall look a little later as to some of the things you need to consider. So your attorney must also help you make your decisions, your own decisions. And they must make every practical step so that you are the one making the decision, not them. And they can only treat you as unable to make a decision if they have not succeeded in helping you to make that decision. So it's quite a severe responsibility. So it's important that you think clearly about who you would like to assist you. Your attorney must not treat you as if you are unable to make a decision simply because you're making an unwise decision. For example, the person wants to possibly sell something and you're thinking, no, that they shouldn't be selling that. They should leave that one and sell something else. But that is their decision. And as long as they have that capacity to make the decision, it may seem unwise to you, but it is their decision that matters. Your attorney must act and make decisions in your best interests when you are unable to make a decision. So this is really someone that you have entrusted with making important decisions in your life, when you are at a point in your life when you're at your most vulnerable. So before your attorney can even make a decision, they have to consider whether or not they can make the decision or act in a way which is less restrictive of your rights. That's why they must try to help you and discuss with you to make that decision. So we have a question here. Can the LPA also be a main beneficiary of a will? Very, very important question. Very, very interesting question. And we will get to that a little later, and we'll definitely get that answered. So the provisions are also explained, and who can and cannot act and in what capacity they can act in the application form and the guidelines itself. So when you get the form, you can go through the guidelines, and at part A8 of the form and also in the code of practice, you can see what the guidelines are in relation to what the beneficiary can, not the beneficiary, but what the attorney can and cannot do. But before an LPA can be used, it must be registered with the Office of the Public Guardian. It may be limited as to when you don't have capacity, that's the only time the person can act. or it may be limited to, okay, once it's registered, this person can act on your behalf. Now, many people believe that once you have issued a lasting power of attorney, that it cancels your rights. That's not true. You as the donor can cancel your LPA at any time, as long as you have mental capacity. So that's why we keep harping on about this issue of mental capacity. You should not leave it to the point where you either don't have or are nearing the end of your mental capacity, or you are unable for some reason or the other to actually use or prepare or give instructions to have a lasting power of attorney done on your behalf. In relation to your will and your lasting power of attorney, that's part of the question that has been asked here. Your attorney cannot use your lasting power of attorney to change your will. So note that this person cannot use your lasting power of attorney to change your will. The LPA expires when you die, okay? And once you have passed, the attorney must, and that's an obligation, the attorney must return the registered LPA and any certified copies with a copy of the death certificate back to the Office of the Public Guardian. So I know that it's a partial answer to your question. The LPA cannot, the person who has the lasting power of attorney, the attorney, cannot use your LPA to change your will. And you can, at any time, change your lasting power of attorney and change the attorneys once you have that mental capacity. And there's a great obligation on the person who has received the lasting power of attorney to send it back once you have passed, and any certified copies, including your death certificate, they must send it back to the Office of the Public Guardian. So in answer to your question, Janet, welcome. It's lovely to have you here again. So in answer to your question, whether or not the person that you appoint can be a beneficiary under your will, the answer is yes. There is no exemption on a person because they are a beneficiary under your will not to be your attorney. But what the attorney cannot do is change your will. And the attorney is simply someone that you trust. For example, if you've got a child and your child is your beneficiary under your will, the law is not saying that you cannot appoint your child as your attorney. That's not the case at all. The child must simply understand that they must act in your best interest and they must take their responsibility seriously. So all the things which I have mentioned here, these are the obligations which have been placed upon them. And once you have mental capacity, you can change your LPA at any time. So if you fall out with your child, then you get rid of that child as an attorney. You appoint other people and you present another LPA to the Office of the Public Guardian. So the key issue here is mental capacity. Now, I would like to really get into the crux of tonight, to just delve into how are you able to save big in relation to a lasting power of attorney. Now, there are several ways you can save big, because the minimum cost for a lasting power of attorney is between £500 and £1,000. When you have to call in a solicitor to do it, when you've left it late, it may even cost much more than that. And we shall see that a little later on. So the way you can save big is that you are able to actually do this when you are healthy, when you are strong. You can do it online. Most people who are aged can't actually prepare a lasting power of attorney online. They probably are not very well versed in online things. And you can also use anyone over 18 who can witness your signature, and who can be your certificate provider if they have known you for at least the last 2 years. Also, you can use a friend or a colleague who has known you for 2 years to be your certificate provider once it's not a family member. So you need someone to confirm that no one is forcing you to make a lasting power of attorney and you understand what you are doing. So if you're using someone who has known you for a long time, it's an adult, this person has known you for a long time, you believe that they can confirm to the Office of the Public Guardian that no one has forced you to do any of what you are doing, then certainly you can go online with them. You can bring your attorneys, the persons you wish to appoint with you, and you can do all of this online. If you don't want to do it online, you can print the forms, and by printing the forms, you will be able to sort things out, fill it out, have your attorneys with you to sign that they know what they're doing, they accept the role that you are putting on them, and they accept the responsibilities that you have given them. So if you do it that way, you only pay £82, which is the cost of registration at the Office of the Public Guardian. If you have printed the forms, then of course you'll have to pay the cost of postage to the Office of the Public Guardian. But if you have done it online, you simply pay the £82, which is due to the Office of the Public Guardian, and you have saved yourself loads. However, I must also point out that you need to ensure that you carry out your due diligence at this point. And your due diligence is that your attorney cannot be your certificate provider. You must know those things. The person that you have appointed, the person or persons, because you can appoint up to 4 persons, and you can also appoint replacement people. So in case the people you have appointed as the main people can't act for you, you can also appoint replacement attorneys. Now, both the attorneys and the replacement attorneys need to sign. So you must have all these people there able to sign to show that they have accepted the role and they appreciate and understand what their responsibilities are. But those attorneys cannot be your certificate provider. Your certificate provider being the person who is saying, look, I know this person, I've known them for 2 years or more, and they are making this decision and of their own free will, and no one is forcing them. So this is the person who can sign and witness your will, not your will, who can sign and witness you preparing the lasting power of attorney, and who can witness the signature, your signature as the donor, and also the signature of the attorneys that you have appointed. So your attorney must be available and your replacement attorneys must be available to sign. And if you want to appoint 4 people, you must have all of them there so that they can sign on your behalf. So that the Office of the Public Guardian will know that these people are going to act for you and they have agreed to do so. And someone has witnessed their signature, usually the certificate provider. Now, how can we also save big on LPAs? Look at this situation now. If you had done it over here before, when you are able to do it and you are young and you have all your mental capacity, it's only £82. If you decide to do it when it's much later in the day, if we take a look at this picture here, what are some of the issues that we may have to be dealing with? As you can see, this person is simply staring at the window. I don't know what their mental capacity might be. It may be we run the risk at this stage, when we do it this late, that the person is already suffering from dementia. You may require the services of a doctor or a lawyer, or if necessary, someone who is certified to assess mental capacity. For example, if someone can only respond by moving an eye, I certainly for sure, although I am a lawyer, will not go in there and tell myself that I can write that, yes, this person is mentally capable, because it's out of my league. As a lawyer, when I go into a situation, I go in to speak with that person, ascertain whether they can understand what I'm saying to them, speak with them privately. Can I have a rational conversation with them? And am I sure that they know what they're doing? They know who their attorneys are. They know who their replacement attorneys are, and that they are doing this voluntarily. But when you've left it for the person to already be in a state where you're neither here nor there, you need a doctor or you need someone who is certified in assessing mental capacity. So they will need to confirm that you are not being forced or unduly influenced into making this lasting power of attorney. And when you leave it to this stage, this person, bless them, they may not be able to recall the names or addresses of the people they want to notify, because the notification when you're preparing a lasting power of attorney is a safeguard. If you have come to a point in your life where you are getting a little elderly and you are preparing this lasting power of attorney, your children might be living very far away, and you've got to appoint someone who is close by, there is a section of the form which allows you to notify people. But you need to know their names, you need to know their addresses. And if you don't know their names or addresses, then they cannot be, no one can be notified on your behalf. So it's important that you do this at an earlier stage in your life, and that you are able to recall who your replacement attorneys could be, because they need to be present. You need to have invited them to your property or wherever you are preparing this document so that they can all sign. And so we don't want to leave this too late, because we run a very high risk of the person not being quite there, and we increase the cost tremendously. For example, for a situation like this, which we have just seen, it could cost anything between 500 and 1,500, and that's on the lower end. For example, you have gone in there as a lawyer, and you have spoken with this person, you see they can have a conversation, but the fact that you have to call a lawyer out, they will charge you. They will charge you for their time. They will charge you for the fact that it's all about by the minute. They will charge you by the minute to do this for you. So you don't want to leave things that late. You want to do it as early as possible, because the risk increases the later you leave it, because the person could be suffering from some form of mental illness. So here, your due diligence is to consider whether the services of a doctor or a lawyer is required, or an independent assessor of mental health. Now, for some of these situations, a GP would not do. And for some of these situations, a lawyer would not do. You really need someone who is an independent assessor of mental capacity. Mental capacity. So you go into a situation and you're like, this person can only respond by lifting a finger, moving, you're not sure what's going on there. You need to get an assessor of mental capacity. And that person will write a report, and it may cost you anything between 2,000 to 5,000 pounds, but it will protect you. And that's the due diligence that will go into that. But if you had done it earlier, as we explained previously, then you would not have to incur that excessive cost. But as I said, if the longer you leave it, the greater the risk. Now, there is one other way that you can also save big with a lasting power of attorney, and that would be by simply, if you are on a reduced income, not, well, some people are on benefits, and people on benefits, there is a scheme where they can ask to pay a reduced fee. We saw earlier that the fee that is paid is £82 to the Office of the Public Guardian. But if you are on a low income, which is below £12,000, and you receive income support, then you can ask to pay a reduced fee in relation to what you need to pay for the registration of the lasting power of attorney at the Office of the Public Guardian. And you will need to complete a form called LPA 120. You also need to provide proof of your circumstances, because it's not going to be accepted that you can simply get a reduced fee at that time. You need to provide the proof. So these are ways that you can save, and you need to do this. Remember, we have said you need to do these things when you have the mental capacity, because that's the key. All of this is governed by the Mental Capacity Act of 2005. So how then do you avoid the stress that comes with doing this very late? You do this by educating yourself about lasting powers of attorney. You consider who, for example, you would like to appoint, as you have the mental capacity right now. Who can be your certificate provider? We have discussed who the certificate provider is, someone who has known you for the past 2 years and who can sign and say, I know this person, they're doing this on their own free will. And you can also, the certificate provider can witness the signature of the donor, who is the person who wants the lasting power of attorney in place. You can also secure a copy of my book, How to Write a Tax Efficient Will, where you can certainly learn more about lasting powers of attorney. So tonight, I hope you have found the information very useful. I'd like to thank everyone who has attended. Okay, we have some questions here. Are 2 LPAs possible? What happens if 2 LPAs are appointed and they both disagree? Is there a public guardian office mediation process, or does it then require court intervention? Okay, that's a very good question. In relation to that question, you can appoint up to 4 persons to make decisions either jointly, either severally, or you can appoint a limited number of people if a number of people as replacements. Remember, you can revoke your power of attorney at any time. You can revoke it at any time, and it's all about mental capacity. So if you have lost mental capacity, that's where some other intervention would be necessary by a third party. But once you have mental capacity, then you are able to revoke your lasting power of attorney. So the crux of everything here is mental capacity. Do you or do you not have mental capacity? You can appoint 3 people, you can appoint replacements. What I have found that is very interesting is that the way it seems to work is that you can have those, if you have appointed 2 people to act for you, and then you want to add someone later, no. They would ask you to revoke the entire thing and make a new appointment. But if you have the replacement people already mentioned, you can simply write in and say, I would like to replace those persons here with my replacements. But what they do not do is, once you have made it, to then send more information for you to add people later. So it's best to have the appointed people and then have your replacements. So if anything happens, you can say, I no longer wish for these 2 people. They are no longer acting for me. My replacements will be acting from here on. So tonight I want to give a special gift to everyone who is on tonight. I decided that as you are all making the effort to join, I will provide you with 50% discount signed copies of my first edition of How to Write a Tax Efficient Will. It's only £7 tonight. So if you would like to receive a copy, if you don't have a copy, the book is $14.95 online. And if you would like to receive a copy, please feel free to make the payment on PayPal, £7. And it's on my PayPal account is deborahbowerswillwriting@gmail.com. So if you make a payment on deborahbowerswillwriting@gmail.com of £7, I will post the book to you. You will have to send me your address so that I could post the book to you, but it's only £7 that will contribute towards the shipment, the shipping cost or the postage cost. And also it's going to be a signed copy. Alternatively, you can go in and purchase the latest version of the book, which is here, How to Write a Tax Efficient Will, the second edition. And you can, if you have already bought the second edition, which is this book, you can still pay £7 on deborahbowerswillwriting@gmail.com, and I will send you a signed copy of the first edition, which became the #1 bestseller in the law section of Amazon. You can see it's in tax law here. It was a #1 bestseller. So people have found the book very useful, and it addresses will writing and in some of the inheritance tax provisions. So you can achieve a tax efficient will. If you wish to contact me, of course, my number is here. It's 079-818-10322. Again, 079-818-10322. And you can send an email at deborahbowerswillwriting@gmail.com. I only have a limited stock of these ones. It's only 50% discount tonight. It's only £7 at 50% discount. So if you wish to receive a copy in the post, please send an email to me at deborahbowerswillwriting@gmail.com, or you can make the payment of £7 on PayPal to deborahbowerswillwriting@gmail.com. Either way, I will send it to you. What I will also ask you to do as well is to subscribe to my YouTube channel. I saw last week that I almost ended up having about 2,000 views on the webinar that we did last week on the inheritance tax strategies. So I can tell from that people are finding this extremely useful. They're finding these topics very informative and very enlightening so that they can get their house in order. We live in a time right now where every bit of help counts. So I'm asking you to please subscribe to my YouTube channel, give the videos a thumbs up, share with your friends and family. And I shall also be putting this video into the YouTube channel so other people can enjoy it. There are people who were wishing to get on tonight who cannot make it. So I'll be sharing this video with them as well so they can have a view of the replay. Are there any questions? It's all up to you now. Any more questions? Any hard questions for me? I see Govinda is giving me some very hard questions tonight, but some very good questions, Govinda. I really appreciate that. Yes, you can also unmute yourself and ask me my questions. Someone has bought a book. Did I buy the newest one? Did you buy the red one or did you buy the gold one? The gold one is the latest version. I'm also happy to send you the book at this price. If you've already bought one.
I bought the red one, Deborah. Okay, I didn't know. This one came. Is that the latest?
The gold.
Oh no, it says 21-22.
Okay, that's fine. That's fine. I will send you a free copy. Just send your email to me. Put your email address to me via email.
Yeah.
I will send you a free signed copy.
Okay.
You've been a great fan, Janet, and you deserve it.
Is there much difference in the two?
The gold, yes. The difference is mainly in the red one. The emphasis was looking at how COVID was affecting people. The stories around COVID. And the inheritance tax information is exactly the same. Nothing has changed. So the storyline is around COVID and how it was affecting people. In this version, it's not necessarily about COVID. It's just about a life. You know, it's not around a person's normal everyday life. I thought COVID is a bit of a depressing subject, you know. Lots of people suffered terribly during that time. And I did not want to maintain that depressing state of loss. So I made it a bit, I changed the focus of the writing and made it a bit more palatable to where we are right now with the economic conditions. So that's the second edition, which is the one you got, focuses on our economic circumstances right now and how you can save. It also addresses the lasting powers of attorney. If you flip through it, you will see that there is a chapter, I think it's about chapter 9, where Jane is appointed with her sister as the attorneys for her parents. So you'll see that it goes through it there and the forms are in the back. Yeah?
Yes.
So you do have the latest version. And don't forget, you can actually download. It tells you where you can get the forms from online to download. So you can, if you want to download it, or you can simply stay online and print and complete the actual application. But you must have all your people that you want to act on your behalf present, your attorneys and your replacement attorneys, because they also need to sign. You also need to ensure that they understand what their responsibilities are. There is a section on the form that explains to them what their responsibilities are. You are more than welcome, Govinda. I know you are an expert in the law, so I was very daunted when I saw you here, but I'm glad that you came and you really did ask some excellent questions. And I appreciate that. So you helped me give even more value to the people who are on the chat tonight. Thank you for that. And thank you for taking the time to be here. Any other questions?
Deborah, sorry, I missed most of it because I was to be on another chat, another site. But this presentation this evening, is it recorded that I can watch it again, or?
Yes, it is recorded, and I am going to put it online, just as I did the one last week. You know, the one last week got over 2,000 views.
All right.
And it has over about 70 thumbs up. Don't forget, guys, to share and subscribe, because I really try to take my time to provide you the best information possible. I know that everyone is struggling right now. Money is tight, but there is so much information that if you only knew, you would not have to pay so much. And I'm just going to help you identify the pitfalls. So this presentation is also going to be online, and you can watch the replay. I will also send it to you on your phones so that you can all watch the replay on your phones or on my channel. Yeah, so like and subscribe and share with your friends and family, and give me a thumbs up. It all helps. I know Tesco says every little helps, but in the online world, it's something similar. Like, subscribe, and share. And if you need to get a cheaper copy of the book, you need to get a discount. I'm offering it at £7. Just go in on Deborah Bowers Will Writing at gmail.com and pay your £7 via PayPal. And I will send you a signed copy. You know, the last edition, the first edition is up to date as far as the inheritance tax provisions are concerned and the will writing provisions. There's nothing wrong with the information there. It just does not have the part about lasting powers of attorney. And its focus is on the circumstances surrounding COVID and people having to write their wills, not having a witness available, and how are they going to do that? So it also addresses holograph wills and how they could do these things when they don't have people around to sign on their behalf. Because in the COVID period, we couldn't go out to each other. So the book was written with that in mind, showing you how to write a will, how to make sure it's valid, and also how to write a will if you've got nobody around, but you need to write a will. And also understanding the inheritance tax provisions, how to think about your circumstances. Because as I said, I'm not a financial advisor, but I will give you a few tips that you need to think about. And when you go to speak with your financial advisor, you can raise those issues. If some people come to me and like their assets are so vast, I'm going to say to you, look, you have surpassed the threshold that would be applicable to you. You need to speak with a financial advisor. So I will just highlight those areas for people, but I cannot be held accountable, and I cannot professionally give people financial advice because I am not a financial advisor. I'm not certified to give people financial advice. But I can say, okay, I know the law says this, that you may wish to go and consider these things or get some financial advice. Okay, so it's Deborah Bowers willwriting@gmail.com. What I also would like to do, I'd like to include all of you on my mailing list. So you can know when the next thing is coming out. You can decide, okay, yes, I want to join this webinar. I am going to do this every Wednesday at 8 o'clock. So I can send you the information in advance. The link, from now on, you can use the same link every week. So I've made the meeting simply a recurring meeting where you can use the same link every week. So if, for example, you don't have to remember a new link. Once you have the link from today, you can simply tap into that link and come to the meeting. The first link was a link that was a one-time use link. So I decided to provide you with a link which you could use every single week so that you don't have to have the headache of remembering what the link was. Once you have already received it on your phone or you received it in your email, you can then use it repeatedly time and time again. Any other questions? Okay, I'm going to mute you because it's causing a disturbance. Any other questions from anyone? Is there anyone who missed anything who would like me to explain to them what they may have missed? I'm quite happy to do that. Because if we go through again, we explained how you can save big if you do this early. You won't have to pay as much as if you left it late in the day, and why you will have to pay much more to sort it out if you have left it late in the day. My encouragement here is to help you understand that it's best to put in place lasting powers of attorney for your financial decisions and for your health and care decisions as early as possible, because it's all about your mental capacity. And once you have mental capacity, you should put in place lasting powers of attorney whilst you have your mental capacity. Don't wait till it is too late when you are unable to think clearly when you are unable to recognize the people around you to make those, or to try to put these things in place, or when you are going through an illness which is crippling you. Okay, so we should try to put these things in as early as possible. And if you put it, if you complete one whilst you still have your mental capacity, it will cost you less compared to when your family has to assist you in getting it done when things are much worse, and either a doctor, a lawyer, or someone who is a specialist at determining mental capacity needs to assist in arriving at a decision as to whether or not you actually have mental capacity. Okay, so if there are no further questions, I shall say good night, and I shall have this on the YouTube channel. I shall also send all of you a copy of the replay so you can listen to it all over again. And don't forget, if you wish to have a copy of the books, it's at a 50% discount, £7 to be paid on PayPal to Deborah Bowers willwriting@gmail.com, and I will post a copy of the book out to you. That will be the first edition. It will be a signed copy, but the information is up to date. And in relation to the second edition covers lasting powers of attorney. If you would like to have a copy of the second edition, a signed copy, you can also just send me an email and let me know that you would like to have a copy of the second edition, a signed copy of the second edition. I will need your address. So with that in mind, and there being no further questions, I shall say good night and stop the recording. Good night to you all.
Good night. Thank you.